And this, of course, will be of a lot of interest, especially when it comes to family matters where widows who choose to remarry will now be entitled to inherit property from their previous marriage. This is after the High Court annulled sections of the Succession Act, declaring them inconsistent with the Constitution.
In a case filed by Ripples International, a non-governmental organization involved in the protection of women and children in Meru, the High Court has annulled sections of the Succession Act that denied widows property inheritance once they remarry. Section 35 of the Act says where interstate deceased has left one surviving spouse and a child or children, subject to the provisions of Section 40, where an interstate has left one surviving spouse and a child or children, the surviving spouse shall be entitled to a personal and household effects of the deceased absolutely, and B, a life interest in the whole residue of the net interstate estate, provided if the surviving spouse is a widow. That interest shall determine upon her remarriage to any person. Ripples International argued that Section 1B of the clause was unconstitutional and effectively infringed on the rights of a widow. The rights group also cited Section 36(1)B, which has similar provisions as Section 35(1)B, except in this case, an interstate leaving behind a spouse but no child, as unconstitutional. Judge Edwin Morethi, while annulling the two sections, effectively restored the right to own property for widows who choose to remarry. Justice Morethi, however, declined to annul Section 32 of the Act, ruling that the petitioner did not provide sufficient evidence to warrant the sought declaration. The said section exempts inheritance of agricultural land and crops or livestock in West Pokot, Wajir, Turkana, Garissa, Marsabit, Tana River, Samburu, Lamu, Isiolo, Kajiado, Mandera and Narok.